Next application submitted is the site application submitted by MBV Engineering to allow the construction of a 4,000 square foot corporate office, 10,000 square foot hangars, two 10,000 square foot hangars, two hangar office expansions of 1,365 and one 1,800 square foot respectively for Corporate Air Inc., located at 3450 Airport West Drive, and the number is PS 1500009. And Tim, I'll ask you. You're going to make, or Sherry? I guess you're going to make.
Sherry.
Yes.
Pardon me.
Oops. Yes.
We got to do.
Oh, any ex parte? Thank you. Thank you. Are there any ex parte information to be?
I have none.
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 Staff, none. Okay.
None.
Staff presentation then?
Now swearing in of...
Swearing in? Okay, got it. I can go back and start reading things
If anybody's going to testify on this, if you'll stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Okay.
Now I can make my statement, huh? It's nice to have people support you.
Okay. Thank you, Mr. Chairman. As the chairman mentioned, this is a major site plan located at 3450 Airport West Drive. The property owner is actually the city of Vero Beach, but Corporate Air Incorporated is the leaseholder, and this site plan is for the Corporate Air Incorporated expansion. The applicant is MBV Engineering, and the zoning is airport, light industrial, and the future land use is industrial. The existing uses on the property, there is an existing Corporate Air aircraft hangar totaling approximately over 16,000 square feet with associated parking. That hangar is located on the east side of the property. The area of development is approximately 6 acres, give or take. This site plan is requested to be in 2 phases. The first phase is to construct a 4,000 square feet Corporate Air main office located towards the west side of the property, and an 1,800 square feet accessory hangar office to the existing hangar located on the eastern side of the property. Including that in phase 1, improvements such as internal drive, stormwater, utility, and parking improvements. Phase 2 of the project, a little longer term, is proposed to construct 2 additional aircraft hangars totaling 20,000 square feet, and also including 1,365 square feet of accessory office with additional parking spaces. And also, somewhat unique to this project, you've noticed in your backup there we included the overall master plan. And I just want to mention that the overall master plan includes what you're proposing, what you're looking to take action on today, as well as the airport's west apron development and the actual stormwater improvements to the north of the project. The surrounding zoning and land uses, they're all airport related uses throughout that area. The staff evaluated the proposed site plan in terms of the standards in our land development regulations. We also routed all to all the applicable review agencies, and in this case, Public Works and the airport staff. They've been very active in review and support. We included all that information in your backup, but basically, to summarize, the project meets our open space, our setback, our landscape, parking, stormwater, and all the other regulations. I did mention earlier that the stormwater retention area is located north of the site on adjacent property, which is also owned by the City of Vero Beach. The traffic impacts are below the threshold for a traffic study. So staff finds that the site plan is compliant with the land development regulations. In addition, the staff reviewed the site design performance standards that are in the code and also found that the proposed site plan meets those standards, especially including that this use continues similar uses in the area, including the expansion of an already existing aircraft hangar. And they're compatible surrounding with the airport operations and the city government uses to the south. The driveway and parking meet the code requirements, and also the staff finds that the site plan is compliant with those performance standards. Given that review and staff's analysis, we are recommending approval of the site plan with the 2 phases. And we have the standard conditions that are on page 3 of of the staff report. And I just want to bring up, there are a few that are in addition to the standard ones. One in particular is the site plan will be required, or the applicant, will be required to submit the actual building elevations and floor plans to us for review prior to the issuance of the development order. So you notice you don't have the elevations in your package.
Elevations.
Correct. But the site plan indicates the maximum height of the buildings, proposed buildings, and they will meet the maximum heights there. We just don't have the actual floor plans and elevations yet. The applicant is working on those, but they're not available as of yet. So we've conditioned the review today to state that they will be provided and will be reviewed by all the review agencies before we issue the development order. Also, I want to mention, and that goes back to one of the comments that our Public Works Department had about the doors swinging in and out. So just so you know, that will be taken care of prior to the development order. The remaining comments from Public Works are very straightforward. Same with Planning Department, other than we added a comment to continue to coordinate the improvements with the airport staff and their engineer, because this is a dual project, if you will, so there's some continuing coordination that, of course, we will be done, and we wanted to state that there. We also, the standard tree removal permit, we've put that in there. And then at the end, we also added that because it's a phased project, that we added language that gives some time frames for the phases.
Oh, that was okay.
And that's number 8, the last comment on the staff recommendations. So with that, I'm happy to entertain any questions. I know the applicant is here, and also the airport staff, if you have any questions.
Just one qualification on 8 that you were just on.
Yes.
Phase 2 is requiring a CO, but you don't mention that for Phase 1. Is that the reason for that?
The Phase 1 is made within 6 months, which is standard approval, and final inspection is 2 years. I guess we call it a final inspection. We probably should say CO.
Okay, thank you.
We should add that, yes.
Sherry, my first question is that we're giving them additional time because it's a multi-phased project. Does this approval, does this application, is 2 years enough for them to do this, or is that what they've asked for, so it's nothing we're restricting them by?
That's correct. They've proposed this time frame.
They'll have everything applied for, start
correct
in 2 years.
That's their time frame. We also realize, and there is, I guess you could say, a review or not exception, but there are conditions where, as long as the project's moving forward, the planning director can issue continuing time frame with given parameters. So it's not a all or none type of thing. It's just that we like to give some time frames because we don't want projects to go
Yeah,
into forever.
Yeah, usually they're going to run, if you don't specify differently, they'll run, it's 2 years from start 6 to get the permit in 2 years. But we have several projects like this and we need to set up a schedule. We don't want this coming,
need
lingering
it
forever
back
and
again.
ever. Because phase 1, you get a building permit, then it's, it may not come back. And so.
Ken, with a question?
Yes, thanks, Mr. Chair. The stormwater management, it's by others?
Yes, it's being coordinated with city, airport, and their consultants, and it was also required to be coordinated with this project and their consultants and our Public Works Department. So it's all of the agencies have been involved, and it will continue to be coordinated.
Okay. And with the stormwater management, the area that has to be constructed for it, is it going to be part of the project where it's their property, or is it the stormwater management on property that they're not leasing?
As I understand it, it's the latter. The airport, the corporate air leaseholder is leasing the portion that's part of this site plan. I could be corrected by the airport staff, but that's my understanding.
So the place where they're going to put the water is their leased land also?
No, it's the city of airport's land.
It's a
all of it is
cooperative regional type thing where the water is it's been planned ahead of time to move all the water to one location.
Right.
And it'll be collected there.
Right.
And there's piping in place to
correct.
identify.
And hence the master plan, if you will, which is to show that there's multiple agencies and partnerships, if you will.
Yeah, when you deal with airports, they have massive stormwater. So these are not atypical of handling those
When
kind
we
of
just
issues.
did the update on that land use.
It looks like there's a little bit of stormwater right here with just local retention. It looks like.
Then since it's on the airport is the airport is working in conjunction with the leaseholder when they are constructing the pond, is the expenses, or the holding area rather, is it shared with the company that's doing all the buildings, or is it being picked up solely by the airport fund because it's on airport land?
Right. I'd have to defer to the airport staff if they know the answer to that, or MBV engineering. But Danielle probably knows.
Danielle Gernert with the airport.
Have you been sworn in?
Yes, I have.
Okay.
The stormwater permitting is actually done and completed because this project is in conjunction with another project that we are doing. We have an apron project that we are working with Corporate Air in that location. So the stormwater permitting actually was done on our side, which took into consideration the improvements that were going to be done on this site. So the airport has already taken care of that, and the stormwater stuff is on our side.
All right, and with that being said, since the stormwater issue is on y'all's side, the airport side, the management and the upkeep of the holding area will be borne by the airport?
It is on airport property. It's not on their leased property. That is correct.
Thanks.
Sherry, could I here's something just to give me some edification? I'm looking at these drawings right here. Does this connect right to a runway or something? Does it lead to it? Is that what it?
Yes.
Airplanes can get in and out of this hangar back onto the.
Yes, if you look at the
that's what
if you look at the master plan section, that's probably the best way to the best one, and it's the most clear, and it shows towards. And Danielle, it shows on the west side connection in the apron and the proposed taxiway. And if I show you on the
that's what I thought. I wasn't sure.
Probably the easiest way.
Sure, I think I have it. So you're on track. I just wanted to clarify because I didn't know it.
It's basically, this is the proposed office, and then this is.
Their proposed stuff is outside of our fence limitations. We're doing the apron work on the inside of our fence, which comes up to our apron, a holding apron, and then a taxiway that leads to the runway. So this construction is done outside of the fence. They will have access with the hangars being there onto the field, which is normal for any of our FBO operations that we have on the airfield.
So there's a coordination between the leasee and the airport to make these things like fences and access and things. That's worked out between y'all.
Absolutely, we've done all of that.
It's not the responsibility of this leasee, but more of the airport authority.
Correct. We've taken into consideration all of this. We've worked with MBV. Our engineers have also worked with MBV in constructing this whole project. We've looked at elevations. We've looked at their building elevations versus the apron elevations, the ramp elevations, the runway elevations. All of that stuff has been taken into consideration.
And right now, are you representing the city? Are you representing the staff? Or are you representing the applicant?
I am airport staff, and I always represent the city of Vero Beach.
She is the airport staff.
She has.
Lisa would say, wait a minute, Lisa's back
We
there.
don't need to hear from the applicant at all anymore. Is that right? I understand how we're moving here.
I have one other question. Since we're talking water here, there was another water issue that is happening out at the airport, but it has nothing to do with this. And I want to ask this question so it's on record. Since this is an airport project and you're working with the private sector with this area, the whole all the water, which is going to be quite a bit of water, all the fees and the upkeep and the maintenance is all under the Airport Enterprise Fund, correct? And all monies will come from there for future maintenance of this. Is that correct?
Because the stormwater requirements we had to do for the project that we are doing, our apron project and our ramp project. This then was taken into consideration when Corporate Air decided to do their development.
So
This was always planned for them to do their development. These
Right.
projects have just been joined together to be able to get done quicker and easier.
I understand that, but the maintenance and everything else
It's
and,
all on
and
the
associated costs are picked up by the Airport Enterprise Fund.
Correct.
Pursuant to federal law.
Correct.
All this is approved by the FAA.
Well, there was I can't bring it up at this hearing. Yeah.
And Homeland Security.
There's other water issues out there, but I can't bring it up with this hearing. That
Correct.
I want to make sure the
it's all
Airport
been looked at.
Enterprise Fund, since it's a water issue, water project, you guys are picking up the tab.
We've
Thanks.
looked into it all.
That's Thank you.
Sherry, could you please tell me on this site plan where the existing hangar is?
Yes. If you don't mind, it's easy to show. The existing hangar is right in here.
Okay.
That's what we thought.
And this is the proposed office here, and then that's phase one. This is phase one, which is the new main office, and these are the two future hangars.
Sherry, you'll need
I'm
to.
sorry, I'm not on the record. Need to me to repeat that? Yes, the existing airport hangars to the east here, proposed office for phase one, proposed office, and then the phase two, the future hangars with office space here.
And also, for the record, Sherry, where does Airport West Drive connect to what major arterial?
Okay.
What is that major artery?
Let's see if we can show it. And
Where is
Ryan, you may-
43rd?
Yeah.
Yeah.
Here's Airport Drive West here, and then it circles south, and then this, I believe, is 43rd, right?
Just west of that's 43rd.
Just west of here is 43rd. It's not on the actual drawing, but 43rd is through here.
Thank you.
Any additional questions of staff?
Yeah, just over to sheet 4, that you have it up. C4, there's a reference to wildlife exclusion, a 6-foot fencing modification. It's by others. I know that we have foxes over on that airport property. Is there anything impacting those foxes at this point?
In regards to wildlife fencing, we have taken the airport, the whole exterior north side of the airport, and most of our airport is protected by wildlife fencing, which is 2 feet in the ground, 8 foot above, and then we have barbed wire over that. They bury that fence so that animals like that cannot dig and get into the airport. The foxes, are now outside of the fence. And anytime we have any type of construction with our FBOs or anything like that, that is a requirement of the airport because it's a requirement of the federal, it's our federal obligation as far as the airport is concerned. So all of our fencing eventually will be wildlife fencing. We're doing it in phases with our FBOs so that we did not say to them, you guys need to change out all of your fencing. Whenever they touch the fence is when it needs to be replaced with that fencing.
Okay. Thank you.
Mm-hmm.
They shoot them if they're inside.
I have a question. Sherry,
Yes.
where the proposed runway entrance to the new office building, there appears to be like a shadow that looks like there's a building there right here. Would that be something that would be coming down?
Let's see. Are you referring? No, and Ryan can tell you more though. That's the shading there is he was showing as the work being done by others.
No, this is like an outline of a building that's already there.
I'm not quite sure where.
Yeah, good afternoon.
You're speaking of this area here?
No, over further, like in the middle where. Hold on.
There, right there.
Yeah.
Yeah, right there, right here. There's that shadow of building, exactly.
Yeah, that's actually, excuse me, good afternoon, Chair and Board. Ryan McLean, MBV engineer.
Sorry. Are you the applicant?
He is, yes.
Then let's wait to the applicant, okay? Is there additional questions of the staff?
No, I'm just curious on what that is. If it is a building that's going to be taken down, or
I see what you're saying. It looks like it's by others. It says, and it looks like it's hard to read. It's on airport property. I would imagine that Ryan could tell us exactly what that is, but it's not part of the site plan. Let's just say. Yeah, it looks like some kind of maintenance building.
It's a utility box.
Okay, that's what I was going to guess.
It's a utility box.
Okay.
And all of the utilities in that site are being considered because there also is a well there that is being dropped and being taken into consideration on that site.
So that's going to maintain, that's going to stay there?
We reconfigured all of that stuff so that there is electric that can be still existing on that well.
Okay, thank you.
Quick question, please, ma'am. You said there's going to be a well that's going to be dropped?
There's an existing well that is there that will be lowered slightly, and we will work around that with the aircraft.
You're talking about the surface of the well, not digging the well deeper, but the surface will be below the ground level at some point.
So that the planes can go over top of it.
Is it a new irrigation well for watering the grass?
No, it's a monitoring well that waters the sewer.
Okay, that answers my question. Thank you.
Additional questions of staff? Seeing none, we'll ask the applicant to come forward. I think y'all are in cahoots, though, actually.
They've been working very closely.
Good afternoon, staff. Ryan McLean with MBV Engineering. And I just want to concur with staff's recommendation for approval and here to answer any questions you may have regarding the site plan or development.
Questions of the applicant? Seeing no questions of the applicant, I will now open up the public. To have anybody from the public like to speak? Seeing none, I'll close the public hearing. Any closing arguments by the applicant? By staff? No. Okay, we're ready for discussion then? It's open for discussion, staff.
Well, the way I see this, progressing is that Public Works and Planning will stay very much in touch as this is going along with all the approval processes. I don't see any questions here that concern me at this point. We just did the airport, the land use, the comp plan, recently, and they're going to be working. Everyone's consulting with each other, as I see it.
Well, it's the city in the city.
Yeah.
There's no differentiation.
And Eric is involved. And
does anybody would like to make a motion? Is there further discussion?
None at this point.
Somebody like to make a motion?
I can do that. Agree with the staff's recommendation to allow this to proceed.
Inclusive of all the...
Yes, recommendations, yes.
of all the staff's recommendations. Do we have a second on that?
I'll second.
Linda seconds. Any additional discussion? Seeing none, I'd like to call for the vote.
Mr. Cahoy?
Yes.
Mrs. Hillman?
Yes.
Ms. Polensky?
Yes.
Mrs. Manous?
Yes.
Mr. Laufer?
Yes.
Passes 5-0.
Thank you. Thank you very much.
Thank you.
Okay.
Good luck.
Okay.
Appeal with appeal.
Yeah. Yeah, we're going to the appeal paper, right?
The one that says planning director interpretation.
The item number C is an application A 15-000004, an appeal of the Planning and Development Director's decision to reject an appeal application submitted by Barry J. Siegel for not meeting the 10-day appeal submission deadline in accordance with Section 64.04 of the Vero Beach Code. And this is quasi-judicial, so is there any ex parte information from?
I have none.
None.
I have none also. Anybody else? Okay. And the second one is swearing of all parties now, please.
Right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
And Tim, are you going to make the applicant presentation on this?
Oh, I guess I go first. I don't know what this.
Yeah.
That's fine. All right. Whatever you want. Yeah, I think it said.
No,
The appellant
Yeah, I think
presentation.
so, too.
Oh, he goes
Yeah.
first? Okay.
Yeah.
Yeah, that's what I thought.
Presentation. I did. Would you like to come to the microphone?
Go ahead, Barry.
You have been sworn in. Please give us your name and where you live at, please.
Yes, my name is Barry Siegel. I'm an attorney here in town with the law office of Barry Siegel. My office is at 3096 Cardinal Drive.
First name is Beard?
Barry.
Barry. Oh, Barry. I even read it. I'm sorry.
You have that correct. It's listed as Barry J. Siegel. I'm not sure. I'm actually Barry G. Siegel, but I think we can probably get past that one.
Barry G.
Yeah, call me whatever you want to. It's fine. I mean, as evidenced by even some of the confusion today as to how this proceeds, this is a relatively new process because I believe all of this comes out of a new set of code provisions regarding interpretation of code provisions by the planning director, whereas they used to be interpreted by various boards like yours in the past. The matter that my client, which we have the fortunate ability of, we don't have to get into the details of what we were appealing, what we were seeking the interpretation from Mr. McGarry. But that particular matter now goes through a totally different interpretation period, so we don't have the ability to go to a code enforcement board, for example, as we may have in the past. And so we sought the interpretation of a code provision from Mr. McGarry. Mr. McGarry's response came back to us. If we don't like the response that we get from Mr. McGarry, our ability is to then appeal to you as the Planning and Zoning Board, which is what we've done. The problem and what happened thereafter is that Mr. McGarry sent us a letter saying that our response was untimely and therefore was being denied. And so what is actually here before you is not the underlying matter that we've sought to appeal or the interpretation that we've asked to have clarified, is we're actually just here on the interpretation of the code provisions having to deal with the timeliness of our initial response. And you have, and I don't know that I necessarily need to clutter the record because you have it as your backup to your materials, but a letter dated July 10, 2015 was sent to me as a response from Mr. McGarry as his interpretation of a code provision for on my client's issue. My clients live out of town, but it's fine. We have no dispute that it was sent back to me. There's no issue there. Our response was sent back with a date of July 20. The postmark actually on the envelope from my office was July 21. The reason being the difference in the dates there is our postage meter for whatever will from time to time in the later hours. We as attorneys have the great pleasure of getting to work late hours from time to time. Peggy will tell you tonight. And sometimes our postage meter will actually kick over once the normal delivery times for our area have gone out. And so I know that this one went out. It was finished in an evening work session for me. The reason why we are here is that the code only says that we have to submit a response within 10 days of the planning director's interpretation. And the problem is that you have so many missing factors. Unlike the situation you had with Mr. O'Hare, for example, earlier today, where you were given a very clean, detailed list of criteria to meet, this was written, not to say poorly, but the code provision is missing a lot of details. It doesn't say 10, it says 10 days from the interpretation. Well, for example, I've got a client in a very similar situation to my clients here, but another client that's in China that would never receive his interpretation within 10 days of mailing. And so if the interpretation of the code provision is that you have to travel 10 days, that the response must be in hand in Mr. McGarry's office, or more particularly in Planning and Zoning's hands by the 10th day, you would immediately deprive that client of mine of due process, because it's nearly impossible that something could be delivered to China, for example, in 10 days. And so we raise an issue of how do we interpret what this 10 days, and so immediately our response is, well, Mr. McGarry's response that it must be in his office's stamped in 10 days would violate the constitutional requirements for due process to a client or to a citizen. And so the other thing that I could say is that you've got a code provision here that could lead to many different interpretations. For example, it says it must be submitted within 10 days. Well, does that mean that it has to be here in this building in 10 days? Does it mean it have to be put in the mail within 10 days to be submitted? Your code is very silent on that issue. There is only one code provision in the entire code that talks about submitting documents by postmark or by personal delivery, and it has no application to this section of 64. It has I believe it has to deal with construction plans, revisions. So it has, and so you could almost say that the City Council specifically is ignoring the postmark or in-hand delivery requirements, because that code provision that they've elected to use one place has not been used here, and so you do have a statutory code of interpretation that says if it wasn't specifically said it has to be postmarked or in-hand delivery to be submitted, you could ignore that as well. And so we've got that confusion. What we as lawyers like to do is we like to look for other sources of advice, other similar situations of what we can do. And so what I normally operate under is the Florida Rules of Civil Procedure that have been adopted by the Florida Supreme Court. And that governs every lawsuit, for the most part, that takes place in the state of Florida. And so we have some things that we look there. We have a mailbox rule, or a mailing rule. The first thing that says is that if something has to be responded to that's delivered by mail, we automatically get we provide 5 days extra for mailing. And so Mr. McGarry's approach that, hey, it's the date would be the day from the date of my letter. Well, the Florida Supreme Court tells us in other cases, add 5 days to that for mailing so that you don't deprive someone of their ability to make a well-reasoned decision if something gets caught up in the mail. And something that's interesting is that this it used to be, or as long as I've lived in Vero, about a one-day turnaround for Vero-to-Vero letters. Even though everything was going to Orlando, maybe back in the 80s and early 90s, things were 2 days. Everything's been about 1 day, and then suddenly about a year ago, it seems, maybe it's gotten longer. But our response back, even with the 21st postmark date, was not stamped into Mr. McGarry's office until the 27th. And so we're looking at 6 days, which we have a weekend in there, so we at least have a Sunday where the post office isn't working to process mail, because I do believe Orlando processes mail on Saturdays, possibly even Sundays. And so we've got that problem that we've got 6 days in there. Just so you know, that the letter was written on a Friday, that was the 10th. Our response was sent back on, the postmark was for a Tuesday, and it was received on a following Monday, just to give you an idea. And so what I'm boiling this down to is we don't have a code provision that clearly says when the response is due, when we start taking the 10 days. Is it 10 days from the day he sends it? Is it 10 days from the day he writes it? Is it 10 days from the day I receive it? We don't know. We have a question of then what does it mean to submit it? Is submitting it mean I put it in my mailbox? For example, if I'm in a lawsuit and I put something in the mail, that is deemed served on other parties in that case from the moment I put it in the mail. unless there is a provision in the rules that specifically says it must be in hand in a clerk's office or in hand on that person by a certain date. And so I would encourage you to provide your citizens with the interpretation that is most friendly to due process. Our Constitution requires opportunity to be heard, opportunity to participate in hearings. The most favorable interpretation you can give to this otherwise cloudy provision would be to say 10 days from receipt or 10 days from sending plus 5 days from mailing, and that submitting it merely states that you have to put it in the mail back to the city of Vero Beach. And clearly, with any of those, let alone with the collection of those interpretations, this has been submitted on a timely basis, and we believe that the appeal to the Planning and Zoning Board should be permitted to go forward under those grounds and with that interpretation.
Questions of the applicant?
I have no questions.
I do also. Go ahead. Let me ask you this question. Who received the initial letter? The applicant? I mean, the actual owners of the property? Or did you receive it in your office?
Do you mean the code violation?
The code violation.
The code violation went to my clients.
Okay. And when he saw that, he read the letter, is that correct?
He got the code violation, and they sent it. They're in Chicago, I believe, and they sent that to me and said, Barry, would you please help us with this?
And if he knew he had a short deadline of 10 days, would it be appropriate for him to then either call or make some kind of, to you or somebody else, to make a proper identification that I need an extension of time? When I have a problem with a bill or something, they usually call the person and say, look, this is tight, I need an extra, and most times you would get that agreement. If I just put it in a drawer, I recognize who the problem is. Now, I'm not saying that's the way it happened, and I hear what you've told me. My question, I had about 4 questions. How long do you think you should have had beyond the 10 days to get it here? And I guess that just the day that it arrived, that's how much time did you think that should be?
Well, let me answer your first question, and then I think I understand your second question as well. The notice that was sent to my clients was actually a code violation, and the code violation speaks to very specific dates that things have to be in, that you have to make your responses. And they acted accordingly, we acted, and then my office acted on their behalf accordingly within those specific timeframes. The code violations are very good in that respect, is that they say, you've got to have it in our office on this date or, you're done. And so, with that respect, the client acted very expediently. So translating that over to your second question is that my opinion is that at a minimum, we have 10 days from the day that we receive it to get it in. Because, again, who knows if it's mailed out on the day that Mr. McGarry types it out. And I have no reason to think that he would take it, put it in his desk, and say, hey, I got Siegel this time. That's not my implication at all.
Not questioning there.
But at the same time, you've got a very silent and confusing code provision that doesn't lay out the specifics like other parameters of the code do or like you do with the code. And so I think that the interpretation has to be in favor of the citizen and the citizen's right to due process. And so I think that at a minimum, it's 10 days from the date of the letter plus 5 days from mailing, which is, again, the only reason I say the 5 days is because that's what the Florida Supreme Court has told us is a reasonable manner for doing something like this. And so, but then 10 days from receipt, and again, submission is getting it in the mail back to you.
May I just ask this question? When you were notified by Mr. McGarry of the denial, this was sent to you and not the client, correct?
That is correct.
Okay.
And the reason that I'd have to believe is because we actually list ourselves on behalf of the applicant, and so there's.
And you're local.
I'm local,
okay,
and they're in Chicago. And part of the problem is that when I get something like this in, I've got to reach out to the client and say, do you want to make an appeal to the Planning and Zoning Board? It's not something as simple as, here it is, let me just do it, because it's a very simple application. I don't even think we had to write a check.
No.
But but I've got to talk to a client before I take an action on their behalf, and so clients are busy, and over the summertime, people also travel. I don't remember what it is that took, longer than hey, I just got this today, can I do something about it?
Was it put in the mail before 10 days from the time you received it? Did you actually get it into the mail within 10 days?
Oh, most definitely, because it's actually, I mean, I have to go with the 21st postmark date. I mean, I know what day I typed it out, but the postmark on the envelope, Wayne and Tim reminded me, actually said the 21st. And so I have to go with that. But, and I know that it wasn't hand-delivered to my office. I know it wasn't overnighted from my office on the 10th. And the 10th was the day, the 10th was a Friday. So, I will work weekends, but I doubt I got it the next day. The mail just hasn't been like that in Vero for a while. And so I'm quite certain that it was returned back from well within 10 days of me receiving the letter.
Can I ask our attorney, the information he suggested to us, how specific is our code? Or how
I think that Mr. McGarry is going to have some information that might answer
I'll wait
that.
for that
But there is a section on our code in the very beginning called General Provisions.
Okay.
And this section of General Provisions affects everything in the code unless stated otherwise. And there is a provision in there called Computation of Time that directly speaks to this 10 days that Tim, I think, is going to show you a picture of so you can see it, or I have it here.
You're stealing my exhibits.
Yeah,
We haven't
stealing
gotten
his
your
thunder.
presentation yet. Yeah.
Will you comment also on what he mentioned something about the Supreme Court has some information? Would
Yeah,
that be
and
comment?
I just looked at that this morning because I wasn't sure about if the mailbox rule was going to come up. So this is kind of new to me. So let me just tell you what I found. First of all, there's definitely a Supreme Court mailbox rule for pro se petitioners who are incarcerated in the state of Florida who give something to their jailer. And I don't think that's the case that we have here, so I'll move on to the common law. The common law mailbox rule in Florida has a long line of cases from the 11th Circuit. And what I found there is that the petitioner which would be Mr. Siegel, is entitled to a presumption that his petition was received by the government entity if it was properly addressed and if it was stamped and if it was mailed. And that's not really the issue here. A lot of these cases deal with, did Tim even get it? Let's say Mr. Siegel sent it and Mr. McGarry said, hey, I never got it, so I'm sorry. But that's the common law mailbox rule. But given that little bit of difference in what we're arguing here, some of the things that the case law pointed out to were pretty interesting. And what the cases were saying that unless there's an appropriate reason for equitable tolling of the 10-day limit in this case, and some of the reasons they gave were untimely filing due to extraordinary circumstances beyond the movement's control and unavoidable even with diligence. So it goes pretty far to get you past that 10 days. Then it's jurisdictionally barred. And that's the argument here. If it's outside the 10 days, we no longer have jurisdiction to entertain it in any case. And while it might be interesting if we had the 5-day rule that's in Rule 1.090 of the Florida Rules of Civil Procedure, we don't have that. We have that computation of time that Tim is going to show you, or I can pass it around old school. But that's about all I have to say about that.
Yeah. Different viewpoint.
Okay.
I'm
interested in hearing what Tim has to say. Any questions too?
I have a question for Peggy.
Sure.
Did I hear you right that we are judicially barred from
unless there's some reason for equitable tolling? And what Mr. Siegel is trying to say is the reason is because of the difference in the mailing period between having to go to Orlando anymore and the way it used to be back in the day when you put it in the mailbox here and the next day your neighbor got it. Mm-hmm. And also the fact that his client lives so far away and that the wording in the code is unclear. It's not clear according to Mr. Siegel, but in counter to that, I'm saying that the wording in the front of the code in that provision section is pretty clear. And if you go too far out of the 10 days, how far you go? And staff and people need to know that 10 days is certain.
Okay.
Otherwise,
everybody will take advantage of it.
Chaos, yeah.
Okay, so again, you're saying that we are judicially barred from extending that 10-day period.
I believe that's what Mr. McGarry is going to be arguing.
No, I can't do the legal argument, but you're right. That's what I've been.
And just like any other quasi-judicial hearing, You need to base it on the competent substantial evidence presented to you.
Mr. Chair, I had one question
Sure.
of the attorney that's
ahead, Ken.
representing the applicant, if I could please, sir.
Yes, sir.
When you were making some of your remarks, you said the code was confusing. Was that
Yes.
correct? And obviously you read the code.
Yes.
And it was confusing to you.
Yes.
Okay. Did you call Mr. McGarry to get clarification?
No, I didn't. If that were the case, I don't know that Mr. McGarry is necessarily the interpreter of that particular provision of the code. And it wasn't as a matter of that, as a matter of I've got to coordinate with a client to make decisions, and so we were given a very short period of time. I mean, we didn't get it. I mean, if this was if it was written on Friday, I don't know what time it got out on Friday. And so at the earliest, it's Monday, Tuesday, or Wednesday of the following week that I receive it. And then I've got to reach a client who is not here in town, and I've got to do then, the work in that way. And so basically it was done as quickly as we possibly could. But no, I went on what my interpretation, what my belief and understanding of the code provision is.
Barry, if we take Ken's point and try to move it one step forward, if you're local here, what would have happened? I'll ask our attorney. Can Tim extend that deadline by identifying that to Barry, that he could get some time? Or he said, here's my problem. Can you give me more time? I need some time to talk to my client. I mean, he's a professional and represents himself as such here and is. And therefore...
we have that equitable tolling language. So you may have talked to Mr. Kamin about whether you had any leeway to give even 1 day or 2 days. But looking at the case law, unless there's some reason for equitable tolling of that time limit, and you heard the standard that was given by the 11th Circuit, which was untimely filing due to extraordinary circumstances beyond the movement's control and unavoidable even with diligence.
Even with diligence.
Mr. Siegel's office is about 5 blocks that way, and we're here. So
you answered that question saying, what? Yes or no?
No hurricane.
Did Mr. Kamin advise you in any way on that, Tim?
We got in the same discussion about the debarring that 10 days, but it wasn't a definitive thing. I'm willing to go up and testify. I probably, if I got in a phone call, I would probably give him an equitable tolling. Whether that was right or not,
you'd have done.
I mean, it's a small town. I'm not, if there was a problem, but that may not have been right either. But I'll be honest with you,
that's the Mayberry factor. And it's not a bad thing.
I like that one, the Mayberry factor. I understand.
I guess where I was going with my question, because the attorney that's representing the applicant, he stated there was confusion with the code. To me, that would have been a serious concern that, looking at it as an attorney, to give Mr. McGarry a call right away to find out what's going on, to see what can be done. Mr. McGarry, obviously, if he can't answer some of the legal questions, he's going to get a hold of the attorney right away to interpret, to help the applicant because of the timeliness of an appeal. That's where I was going with that. He stated our code is confused. There's confusion there, and that when he was reading it. So to me, you do the research right away on behalf of the client. Not telling you what to do. I'm just thinking it out loud here from my mind.
Well, if I can respond to that real quickly, because I know you guys have already had a long day and you still have other agenda items. It's not that at the time it was confusing to me. It's that when I now get a response back from Mr. McGarry saying we've denied your appeal to planning and zoning for this reason, I went back and looked at it and said, well, I guess someone could look at it that way. And so that, to me, is confusing. It was very clear to me when I did it, or I would have calendared it differently on my – and I'm thinking here's like an example. If I told you I'm going to have a package to you 8 hours from the time of my flight, when is that? Okay? Is that going to be from the time my flight takes off? Is that going to be from the time my flight lands? That's the problem that we have here, is we've got 10 days from the date of from the ruling. And so is that from the day I receive it? Is that from the time I receive it? Well, it makes a lot more sense for that to take place. If I told you I'd have something for you 8 hours from the time of the flight, I can't guess that there's going to be delays in a flight. I can't tell if we're going to be stuck on a tarmac. I can't tell you if we're going to have weather. I can't tell if we're going to be rerouted. But what I can tell you is from the time the plane lands, I know how long it's going to take it for that package to get into my delivery vehicle and get it to you. And so that is the interpretation that we looked at with this, because if that flight's delayed 10 hours, it's impossible for me to get it to you. And so that's what I'm trying to say, is that this 10-day rule as written, and take into consideration the provisions that Peggy and Tim are talking about, you're depriving your citizens of due process by having the rule like that. And so that is our concern.
I have a question. Mr. Siegel, Barry.
Yeah.
Was the first letter of July 10th, delivered to you by either certified or registered mail by which you had to execute a receipt to establish the receipt date?
No, that was just first-class mail.
Thank you.
It was, right, Tim?
One other quick question. You said due process for your citizens. You're just doing the one person, right?
Well, they're a married couple, but yes.
So it's just this is the case that it's because you keep saying citizens due process. It's your concern with the due process with these folks wasn't really followed through in your opinion.
I'm not looking to set precedent for the rest of the town right now. No.
Okay, thank you.
I have a question. What day was July 10th? What day was it?
It was a Friday.
A Friday? And what day was the 21st?
That's a Tuesday.
A Tuesday. Okay.
Friday and Tuesday, they said. Is that right?
Okay.
Okay. Does anybody have additional questions? Mr. Siegel or Barry?
Not right now.
Not right now. Thank you, Barry.
Take a seat.
Tim, would you like to make your presentation?
Yes. Got exhibits. I'm going to give you all of them at one time.
Thank you.
So what I'd like to do is walk you through how I arrived at my decision.
Tim, I don't think your microphone's on.
Excuse me. I'd like to walk you through how I reached my decision. I've given you all copies from the code and other information that's involved with this situation. On Exhibit 1 is Section 6404, which states, if you look at the request on about the fifth line under A, pursuant to Section 64303, within 10 days of the administrative officer's written decision, not receipt, the written decision. And at that day, we did mail it out. The day we sign those things, we send those out in the mail. So that was that
Those
Friday.
dates are synonymous.
Right.
Okay.
We wouldn't hold up on that, to get that out. Exhibit 2 is what Peggy alluded to, was the computation of time. It's clear how the days are counted. Weekends, it doesn't matter. It's a calendar day, starting from the day of that decision. So there's a 10-day in there. You measure it as in the computation of time into that part of the code. And Exhibit 3 is the actual the date of the interpretation letter, which was July 10th. That was sent out. I just put a cover on there, I believe is in the code. Exhibit 4 is the appeal application. If you note, I believe that's Barry's signature, if I'm not wrong down there, because he was and the date on there is 7/20. I mean, this was the last day you could do it. So this thing, it didn't trot down to my office to present it. You put it in the mail. So on the next thing, and you can see on the top, it says July 27th. That's the date. Everything comes in our office, we stamp it in. So that's 17 days past the date. We're not quibbling about whether it was 11 days, 12 days. We're talking about 17 days. So it was clearly beyond that point. On Exhibit 5, and Barry Mr. Siegel's already pointed out to you on his posting, it was 7/21, which was the following day, and it went through Orlando on the 22nd, and we didn't get it in our office till the 27th. So following the code, I discussed this with the city attorney, and if we feel we've applied the code properly, we don't think there's any misunderstanding of how it's applied.
Mr. Chair, can I have a question of Mr. McGarry?
Yes.
If I understand correctly, Mr. McGarry, sorry. this could have actually been hand carried to you, and it would have met the deadline?
Yes.
Okay, thank you.
And I think the other thing that should be pointed out, it wasn't exactly like a lot of Mr. Siegel sent the application, and there wasn't any follow-up and a lot of reasons why and all that. He did present that to you today, but I mean, as I said, it wasn't a lot of effort other than contacting his client, I assume, as he explained.
One other quick question, please. Did you get any calls prior to the deadline from the applicant's attorney, asking you about a possibility of a little extra time, or they may not meet the deadline?
No, I never did.
Thank you.
Can we ask the applicant that? Can you state that you didn't make any calls also?
No, I didn't believe it was necessary.
Okay.
I have a question. So from what I'm seeing with the date, the last one, Exhibit 5, the date in Orlando was the 22nd, and then it didn't arrive the city office until
Exhibit
the
4, the 27th. That's correct. But those dates, even the 22nd, the 21st, are past the 20th.
I'm not seeing the 27. Where do you see that?
Oh, if you look on Exhibit 4 in the top, you see where our little stamp's in? That's when we received the application.
There's an arrow that points at it.
Yes.
It's very light. Yeah.
I can't hardly see the arrow.
Yeah, I'm sorry. Yeah,
Yeah.
it's...
So it took 5 days to get here from Orlando? Is that what we're saying?
That's what it says.
That'll happen.
That's not. I don't.
That'll happen. In my experience.
I have another question. If this had been sent not in the mail, say it was emailed, scanned and emailed, or copied as a PDF and emailed, would
I would accept that.
that would have been okay?
Yes. In fact, we get applications that way.
I wondered that. Okay.
Is there a reason you didn't choose to do that also? If you thought you were tight?
Didn't even know that was an option. I've been email with Mr. McGarry frequently, but I'd never seen that as an option for any of my filings with the
So
city
you
in the
didn't
past.
consider that as a viable way to expedite?
I mean, again, we look at all this with a great abundance of hindsight now. That with the interpretation that Mr. Gary's put on the code, which again we still disagree with, but yeah, I mean, certainly that was certainly a viable option in the future. I will do it just because it keeps everything electronic for me, makes my filing so much. I have no problem doing all my filings via email that way.
And when you saw the date at the bottom and you knew the date that you put the date on it, is your office 4 or 5 blocks from here?
It's Cardinal Drive.
So you didn't consider just dropping it off at the city?
I would have loved to have dropped it off the city. It's just the city doesn't keep the same hours I do. There was no one here. The best I could have done is put in the utility drop box at probably 8 or 9 o'clock at night.
If he would have dropped it in the utility box at 8 or 9 o'clock at night, what would have been considered? Utility box?
There's the payment box. I'm kind of being a little facetious. Maybe it's a little late in the day for it, but
would the city consider that as a drop-off then?
I don't know, Tim. What do you
Well,
think?
I don't know. I mean, it would go.
But he didn't do it. So
he didn't do it, but he wouldn't pick up.
But you might have had a shot at it.
No,
I think.
it says to the Planning and Development Department.
not to the.
Yeah,
Oh, wait a minute.
Not
No, it doesn't.
No, the Planning and Development.
Fee
No,
to
the Planning and Development Department.
See, that would go through the customer service people
Yeah.
downstairs with the utility. I don't know.
Okay.
But I might add that, I mean, and I've just emailed back and forth with Mr. Kamin on this, but like a court, you all as a board, as a quasi-judicial board, do have the ability to provide that equitable tolling of the 10-day limit if you feel like there has been an appropriate reason given by Mr. Siegel. So you do have that ability, just like a court would have it.
But Peggy, the understanding is that administrator, I don't have that ability.
Yeah, that's what Wayne was saying. That
okay.
You don't have that.
That's what Wayne. Yeah,
it was a little bit back and forth earlier, but
and that's why I could.
Mr. Kamin is saying
but we
that
have that. He doesn't have it, but we do.
you have that ability as a quasi-judicial judge. I have not done the research, but Mr. Kamin.
Even though the argument that you put out before that we're judicially barred.
In this particular case, this was an 11th District case in 2010. The court found judicial barment because there was no extraordinary circumstance that would allow the equitable tolling. So if you can find some sort of circumstance that would allow the equitable tolling, then that would release the judicial barring and we could move forward with Mr. Siegel's client's appeal.
I think, well, maybe I'm wrong, but I think 7 days to get something from Cardinal Drive to the city is unusual circumstance.
But
I really do.
I
just
accept.
think
Can we open public? I think we're into a discussion. Let's move the process along a little bit.
Can I ask a question of clarification, just to make sure that I'm reading this, and that's out of the computation of time. It says, in computing any period of time in the code, the day of the act, event, or default from which the designated period of time begins shall not be included. So, my interpretation is the 10th was on a Friday. It shall begin on the 11th, which is Saturday. Okay? The second part of this is the last day of the period so computed shall be included unless it was a Saturday, Sunday, or a legal holiday. So the last day was Tuesday, the 21st. That is the 10th day. He had ample time, according to this, if I'm reading this correctly, because it fell on a Tuesday, to get it to the office by Tuesday. Am I correct on that?
Tim, what do you think?
Let's see, counting from the
11th.
Okay, first day is the 11th, 12, 13, 14, 15, 16,
Well, the date of the letter,
18,
letter
19,
is
20.
July.
Yeah, it's
July
the
10th.
20th. That's still 10 days from the 10th.
Right. The date of the letter is the 10th, but according to this computation of time, you don't include the 10th. You include the following day, which is the 11th.
Yeah, and it's still the 20th.
Right. So
20th.
even if his postmark was the 21st, the 11th and the 21st, that's 10 days right there. He had plenty of time within that period to get it to the office. That's a clarification that I just, in my head, the way that I'm computing the time.
If you'll allow me, I'm going to open it for public comment now. Anybody like to come forward? Seeing nobody, I'm going to immediately close public comment. And now we'll go to closing arguments from the applicant first, I believe. Is that correct?
Yes, I would reserve a small amount of time for rebuttal if necessary.
Okay.
I mean, the code provision, we're well aware of it in the counting, and that's pretty standard across the board. Doesn't affect really, I think, any of my argument at all. I mean, that's just a matter of how we count the 10 days. I think if it spoke to the issue of when we started that 10 days as far as the date on the letter or something like that, but I go back to, again, my flight analysis. We don't have an interpretation here if it's the beginning of the flight or the end of the flight. We also saw evidence that my letter took an extraordinarily long period of time to get to me. Mr. McGarry's letter to get to me, and as evidenced by the letter going back. And so it makes it very difficult. I can't imagine what that would do to a citizen that lived outside of the area, which is why the 10 days really only logically should run from the date that it is sent. And I know that begs the question, then you're going to say, well, Barry, how do we, everybody's just going to say, oh, we just got it. And so maybe that means that either changing the code provision to specify, perhaps adding a 5-day mailing rule, or, as Mr. Coy suggests, sending them with some kind of certified mail or return receipt, or even better yet, hoping the city can soon one day move to electronic delivery, where everything is just so well documented like that, as we're doing in federal and state court. And so there are equitable principles here that I think if you don't agree with me, if you don't agree that we submitted it on time by putting it in the mail, if you don't agree that we had 10 days from the day we received it, you still have the equitable issue here is that it appears as though the mail is moving much slower than is anticipated when the code was presumably written, and the mail was returned back much slower than I had hoped that it would travel. Certainly, the city hall is on my way to almost everywhere I go, and so it's not a matter of I was trying to do something to skirt the process by not bringing it and personally delivering it. It probably wouldn't have even had to go upstairs to deliver it. Probably could have taken it to customer service, say, run this up. It's not a matter of that issue, but I think that you can find the equitable principles here that do allow you to not be jurisdictionally barred from denying the request, that you can take into consideration all these factors, and most importantly, let these citizens move their claim forward through the proper channels to get their interpretation or at least their opportunity for a hearing in this matter. Nothing further. We're not looking for you to guarantee any kind of result when it comes back to you, but we want you to take every step you can in light of this, in my opinion, confusing new code provision that hasn't really been, the tires have not been kicked, but allow it to not prevent their right to a hearing in this matter.
Thank you. Do you have anything else to add, Tim?
Well, I think that the record speaks for itself, and I go back to it. This thing was mailed on the 10th day, and there was no way it was going to get in our office, even with the weekend and all that. You know, talking about slow mail from through Orlando is not an answer. I mean, it should have been delivered down to our office, and it's from the written decision. There was never a question about this. Never had a problem with this before, and I think it's pretty clear in the code. Whether it could be written better, it would have to be written, but that's the way the code reads right now. Robin, I
interrupted you before, so you were talking. You would like to complete that. Sorry.
No, I'm conflicted, honestly. Am I allowed to have my
Yeah.
comment? I really am. I think to see that it took 7 days to get from your office to here, I think is unusual. I would think it's unusual, but at the same time, I don't think it's unclear. I think it's clear. I don't know if there was an administrative issue in your office. You know, I don't know what the issue was, why it didn't get here, but and I also think that every high school student should witness this and listen to this. You know,
very good.
But anyway, that's my comment. I'm conflicted.
Mr. Chair, when you're done closing this portion out, I would like to make a couple of comments.
Yeah, I think we've completed that. We're ready to go to...
it's just a brief resubmittal, one sentence.
Resubmittal, go ahead.
All the things Mr. McGarry says, I can't disagree with them, but what I can disagree with is if those are the things that the city wants, those need to be put into the code provisions. These code provisions are there to guide the citizens, and any interpretation against these provisions need to be in favor of the citizen in furtherance of procedural due process. And that is our point, is that if these can be read different ways, if you can say something doesn't add up here, then you have to rule in favor of the citizen, in favor of due process, and allow this matter to proceed and allow them to have their hearing. Thank you.
Thank you. Do you have anything additional to add? Rebuttal?
No, I've made my statement.
Thank you. We're now ready for a discussion or a motion. Go ahead.
Thank you very much, Mr. Chair. Just a few comments. We heard about the mail, where the mail took a while from Orlando to get here. Most folks that are in business, we understand the way the mail works. I know myself, I correspond with folk all over the country, sometimes out of country, and I do take an allowance. Sometimes it's going to take longer, and we send correspondence to Orlando. Sometimes it takes more than 7 days. I already know that. It's just how it works with the mail. Why is it so slow? I don't know. Are they sending it by mule? Who the heck knows? But we know it's going to take longer. I had asked the attorney, did he contact Mr. McGarry for some clarity? You know, this is a serious matter here that he's working on for his client. He did not. I'm sure Mr. McGarry would have filled him in. If Mr. McGarry didn't have the answers, he would have sought out the legal from legal counsel here. The code as it stands right now is clear on how the process works, and I don't see how much clearer it can be. It's not that we're denying people their rights, but the attorney's office is local here. Again, and if he would have maybe called Mr. McGarry said, well, you know, this is pretty serious here. You're kind of running out of time. Bring it on over to me. Send it by email. That would have come out over the phone. So I think as far as the process, there was tools that were available that were in the toolbox that could have been used, so this appeal could have been, heard, in a timely manner. And I think ample time was given.
Additional comments?
Yeah, I have a comment. I just feel that even if he didn't have time on the 20th and he postmarked, just say the postmark went over on the 21st. That was the 10th day. There could have been a way, whether it be a secretary or time taken off at his lunch or someone's lunch, to drop that letter off at the planning department. It would have been stamped in the planning department on the 21st. as inconvenient as it is, I've had to run out to do things on my lunch hour. It's just what has to be done, and if a deadline is set, and clearly, I believe that the computation of time in the code is clearly stated. You have the 10th day. It gives you the day after the mailing, and it will give you another day if it falls on a weekend or a holiday. 10 days, and the 10th day being the 21st, it could have come into this city and been stamped in the planning department on the 21st, and he would have been in time. He would not have been in violation, and that's just the interpretation that I have in.
I have a comment. And if I would, I'm just putting myself into these shoes. If I received communication that said I had to respond by a certain date, and I realized I was going to be having some difficulty meeting that deadline, I would have called whoever and said, "Hey, I have a problem. Can you help me? Can you delay a deadline? Can you do something for me?" And you referenced Mayberry. We're a small town, and I just see that kind of cooperation could have been forthcoming. But there was no contact there, and that part I find particularly uncomfortable, that, this is not our problem. And we're moving so much into an electronic world today, I personally don't trust the mail a whole lot. I can't say that this is going to happen, get this, unless it's overnighted and, precautions are made in that regard. I just have a lot of difficulty with it. This letter was very, very clear that an appeal had to be within 10 days, 10 days from the date of this letter, and that's all very clear. So that's my contribution.
Any additional comments?
Yes. Number one, we don't have evidence of when that July 10th letter was received by the applicant or by the homeowner's representative. And if I have to file my tax return by April the 15th and do so even if I take it to the mailbox that's held open till midnight, I have no way of knowing when the IRS receives that tax return until I either get contacted by an IRS agent, which has, or I have been notified by the IRS that I missed the deadline, or that they didn't receive my return. I recognize that there is a 1 day difference between the July 20 deadline for submission and the postmark on his envelope. But having myself been in business with and using postage machines that do sometimes automatically advance the date on that postmark at 5 o'clock or 6 o'clock, whatever that preset date is at the end of their day. I am personally for applying the equitable tolling rule here and giving the benefit of the doubt to the applicant.
Additional comments? Does anybody want to pose a motion then?
I move that we accept the planning director's decision to reject the appeal.
I have a motion. Do I have a second on that motion?
I'll second it.
It's been has motion first and a second. Any further discussion on it? I'd like to call for the vote then.
Mr. Cahoy?
No.
Mrs. Hillman?
Yes.
Ms. Polinsky?
No.
Mrs. Manous?
Yes.
Mr. Lawfer?
No.
Motion fails 3-2.
Thank you. Are there any additional planning department matters?
No, it looks like, I don't know if I can schedule, no, I don't, we have to advertise this thing. I think we have 14 days. Let's see. 10 days before the hearing, we'll advertise this hearing for next Planning and Zoning Board.
Which hearing are we talking
The one you just approved.
It has to come back.
That's what it's all about.
Well, I know that, but
Yeah.
but
That's the one we're going to, I'm going to try to go ahead and do it. Yeah.
So there's time to do that?
Well, I'm going to have to look. We have 10 days, so we might not be able to do it. It's 14 days with the thing, so it wouldn't be till October. Okay?
okay. Any other thing, Tim? Are there any board member matters?
Nope.
A question on how the vote just came out. How does that impact anything that comes forward now as far as a 10-day deadline?
Well, you did it on the equitable estoppel, and you determined there were extenuating circumstances. So you didn't rule against. You took your authority to do that.
Okay.
So I don't see that as changing anything. I think that was your.
You don't see this as a precedent?
No, I don't, because you, as I said, I think it was pointed out, I don't have the authority to do it. So if we get into these, and I do bring it for you, we would have you all make that decision. Okay. So I don't see it as a precedent. All right.
You all understood that the motion failed.
Yeah.
Yes.
To approve Tim's.
Right.
So he was granted his time period.
Yes.
So now that appeal will come back. Okay. Not that appeal, but the appeal for the code violation.
Yeah. It's going to be deja vu all over again.
Sorry. If there's nothing else come before the board,
I have a question. Actually, what I'd like to do is thank our legal staff for sending the updated lists on the quasi-judicial. And my question then is, that's the updated list. So all of the lists that we've received, those items now are okay, unless they're on the updated list.
Yes. No, we prepare the list, not the attorney's office.
Oh, okay. And so what we have here now, that remains on.
No, that'll be back on. We'll
list.
put that on the new updated list.
Okay.
Okay?
Okay. Thank you. And thank you for bringing that forward. That's important. Appreciate it.
Yeah.
thank you. We are adjourned.
Okay.